afternoon. Please be seated. We have two cases on the docket to be heard this afternoon. We'll call them in the order that they appear. The first case is James versus James. Is the appellant ready to proceed?
Yes, Your Honor.
All right.
I would like to reserve 3 minutes for rebuttal. Thank you. May it please the Court, I'm Kristen Adamson of Novy Mendelson and Adamson. I'm here today representing the husband, the appellant, Mr. Rob James. The issue presented to the Court at trial in this case below was only the issue of alimony and what was the appropriate number. This was a 24-year marriage. At the time of the trial, the husband was 59, the wife was 53. The parties had 2 children who had reached their majority. They reached an agreement resolving the asset distribution before going to trial. In that agreement, they agreed that all of the real estate would be sold and liquidated and divided equally between the parties, with the exception of the husband's business real estate, and that he would receive and that he would actually pay to the wife then an equalizer payment of almost $500,000. He was to pay that over a time period of 180 months. The interest payments at 6%, as agreed to in the agreement, was to begin being paid to the wife in November of 2006. So she was to receive income from that equalizer payment prior to actually receiving the equalizer payment. The parties stipulated 6% was appropriate. During all of the proceedings, including at trial, even the expert witness of both parties stipulated that on investment income, 6% was an appropriate figure. It could be less, it could be more, but that was the figure that they all stipulated to. The wife is a lab manager for Southern Community Blood Center, and she was making approximately $54,000. I'm using round numbers for the purposes of this court, but approximately $54,000 a year. The husband has a PhD in toxicology, and he worked in academic positions prior to becoming president of a business that he owned called Terra Inc. Terra Inc. basically contracts out risk assessment guidelines for soil and groundwater cleanups and hazardous waste cleanups. Husband earned a salary, and this was undisputed, of approximately $240,000 per year at the time of the dissolution. Any profits in the company were then bonused at the end of the year, if there were any. The company bonuses had ranged significantly over a period of time. Without getting too much into the dispute of the husband's income, there was some dispute about the husband's income at the time of the trial.
Didn't he make approximately $500,000 a year when you include everything?
Well, the court specifically found that he made approximately $500,000 a year if you were to include the prior year's bonuses and kind of average them out. Over the course of the 10 years, it was only in the last 4 years that he made anywhere between $500,000 to $600,000 or $700,000. Prior to that, it had all been in the $175,000 to $200,000 range. The court did make a finding about his income being that. It was disputed, but it's really not significantly relevant to the position that we have before the court today.
You're not arguing he doesn't have the need to pay.
We're not really arguing that he doesn't have ability to pay.
He doesn't have the ability to pay. I'm sorry.
That's correct.
You're saying she doesn't have the need.
That's correct, Your Honor. And not only are we saying that, what we're also saying is that the court didn't make any determination of that need. And that's what the real error is in this case, is that the court did not make the specific findings of fact required by the statute and required by the case law to determine what her need was in this case. I quote exactly.
He stated in there that her affidavit, which was around $16,000 a month, was reasonable in some of the stuff that I've read in this record. So why isn't that a finding that she has a need somewhere in the $16,000 to $20,000 range.
Well, the court didn't really make that finding. What the court said, and I'm quoting the court's statement, in terms of the monthly figures, I did not put a figure on that. It is clear that they were used to a higher standard of lifestyle beyond necessity, and frankly, I didn't go back and put a number on that. So simply because it was on her financial affidavit and the court granted her $10,000 a month in alimony, the court specifically indicated on more than one occasion, at the trial court, in the final judgment, at the reconsideration hearing, that he really wasn't interested in making that kind of determination and putting actual figures on what the standard of living was. The court...
Well, he did sort of back into it in a way with the one at the end of paragraph 3 on his order. He said the court does not find that the wife's affidavit contains any substantial overstatements or unwarranted claim for expenditure.
Nevertheless, what the case law requires of the court is to make specific findings of fact, and the case law is very clear in every regard that these specific findings of fact are necessary, and it's reversible error not to do that. The court did not, after reconsideration at the very last moment, he said, well, I think it's okay, but he didn't even grant her what was on her financial affidavit. He didn't make any findings of fact that that was appropriate either. He gave her $10,000.
Well, that's the point of their cross appeal, right?
Correct. Well, they say it was not enough. Correct. We argue that he didn't make findings of fact. The mere fact that he didn't make these findings of fact is reversible error in and of itself, even if they were to prove that it was reasonable that these were her needs, which we don't think it was. And we don't think the court made a real specific finding that these were legally sufficient needs as well. Several of the needs on her financial affidavit were for adult children. That has been held to be legally insufficient for alimony purposes, and the court did not look at that. The court also didn't make any findings regarding the fact that over $7,000 of her quoted need on her financial affidavit was for purposes of carrying the real estate. That's a temporary situation. The real estate was all to be sold. Initially in the agreement, the parties had said that the husband would carry the real estate, and then what the judge did was change their agreement. They basically, at the last minute, stipulated, fine, we're not going to go down that road because that's too complicated. So what we'll allow you to do, Judge, is change the agreement. But then what the judge did was say, okay, each of you carry half of it until it's sold, and I'm going to make the husband pay you alimony to do that, regardless of the fact that it's a temporary situation. So our number one position...
Well, that would leave the husband the remedy of modification then when the circumstances changed, wouldn't it?
Well, not necessarily, because the second issue that we have also is the fact that this real estate is all to be liquid, and the court did not impute any kind of investment interest on this real estate. All the parties stipulated that 6% would be appropriate. The court also didn't include in the wife's income figure the $2,300 a month that she absolutely was getting from the investment of the equalizer payment. She was getting that. There's no question she was getting it, and it was part of her income for 180 months, which was guaranteed, and the court did not include that, which would also have changed the alimony calculation. The court did not make any of these findings. What the court basically said was, well, I think this is kind of the income of the husband and wife, and I'm going to split it this way. It's a 30-70 split, and I think that's appropriate.
I don't think he said it that way. I think he found something. The way I read that final judgment, you correct me.
Yes, sir.
If I'm wrong, the judge made a finding and then said, and this represents 30 or 70%. It was sort of like an afterthought. I didn't see that as the order than a judge that I'm going to make finding that you pay 30% versus 70%. Sort of looks to me like the judge was just writing and it just said, in addition to that, it's 70-30, just to sort of highlight what he was doing.
It's hard to know exactly what was going on in his mind, but I don't think I mean, it's pretty obvious that he didn't, at the initial trial, in the final judgment, he did not say specifically, he did not review all of these numbers. He basically said, I think that this is a fair number, 10,000, and by the way, it's a 70-30 split, and that's as far as I'm going to go in this analysis. And that, I think, is the point I'm trying to make, is the court did not really make the adequate analysis of all of this. He basically was basing it on the income of the husband without really looking at what are all the available assets to the wife. The statute, 61.08, specifically says that the court needs to consider After the asset distribution, the marital assets divided and how they were to be apportioned to the parties. Once that is done, there's absolutely liquid assets available to the wife that are investment-oriented and that they can have 6% interest.
So the wife can get 6% interest on the asset she got after everything was split up, correct?
Yes.
And that should be imputed to her.
Right.
6%.
Right.
Are you arguing that the other half that the husband got, that the 6% of the value of that should be imputed to his income?
That's basically what the court was saying, is that this is a neutral factor because I would have to do it to both of them. What I am explaining to this court is that, fine, do that. It's irrelevant to the standard of living of the parties and the need. The court, if you do that, you're still only looking at what's his available income. You're not looking at what has been established as a standard of living of the parties and what is her need based on that. All of the court cases, Elliott and Italiano, and all of the court cases that have come out in the last 3 to 4 years say it's not a one-sided analysis. You don't just look at his ability to pay and then make the analysis so that if he gets more money from investment income than she gets more money from him. You look at what did they do during their marriage and what was the standard of living, and can these assets that she's receiving, can they grant her some income so that the alimony award is lessened? And the court failed to do that, and the court specifically indicated it wasn't going to do that, that this was a neutral factor. That's our second contention, that this is a major error and it's a reversible error. And the Italiano
the court found that her need was $16,000 a month.
I'm not sure the court really found that that was her need. I think it backed into it and said, well, $10,000 is what I'm going to give her, and I think that she may be able to have 14 of her own income, but they specifically found that they were not going to impute any of the income to her from the assets. Specifically said that in the final judgment, and when asked to do so again on reconsideration, said we are not going to do that because of the argument that you have indicated that they would have to do that for the husband. Again, I think the court is looking only at one side of the equation and giving it disproportionate weight. The real side of the equation at one point becomes irrelevant, and that's like the Mallard case, which is a 2000 Supreme Court case where Mr. Mallard basically said, I've got the ability to pay. I've got the ability to pay anything you want. But that's not the issue. The issue is what's her need. And what I'm suggesting to this court is that this judge got very, very, very hooked up in his ability to pay without really spending the time to analyze what her need was. And the investment part is part of that.
One thing about her need that they're complaining about on the cross appeal is that he didn't even consider the tax money that she's going to have to pay on the alimony, which under Florida law, he's required to look at it. And it looks like he eliminated that, so it seems like you have a tough burden to show abuse of discretion here.
I'm not trying to show abuse of discretion. I'm saying it's error as a matter of law that he didn't make these kinds of findings of fact, Your Honor. And I disagree with her analysis of the tax burden, but I do agree that there's no findings of fact regarding the tax burdens in any way. So I believe that this case needs to be reversed and remanded to this court to make the appropriate findings of fact, including adding in the investment income of the $2,300 a month that we know she gets, of the investments of $1.4 million that she's going to have, which does not include retirement.
You concede error on their cross appeal about the income tax that I noted that you didn't respond to that.
Well, basically the reason I didn't respond to that is because I think it's implicit in the whole argument that the court didn't make the findings of fact necessary regarding any of these things, the tax burdens on all of it, the investment income. I don't think that stands alone. I think it's basically, I agree that all of this is necessary. The court didn't make the adequate findings of fact. It didn't really analyze the standard of living of these parties. It basically said, well, these parties have more than the necessities of life, and therefore I'm going to order what I've ordered here. The final thing, according to the Mallard...
So to get back to my question, you concede.
I concede on that issue, yes, sir.
He erred on that part about the income tax.
I agree on that. I think that that's implicit in the rest of it. I agree that they did not, apparently the court didn't consider any of the tax burdens on any of this, on either way. Also, in the Mallard case, it specifically states, if you look at Mallard, which has been argued considerably and well thought out, that there is no savings alimony. And that means that you cannot award a party alimony for purposes of savings. What that Mallard court case also says, if you look at it additionally, is alimony is not awarded for asset accumulation. The Mallard case, Supreme Court case specifically says that. What the wife is arguing in this case is that she should be allowed not to reinvest her assets of $1.4 million, but to be allowed to go ahead and buy herself another beach house, which is asset accumulation. I would submit to the court that that's against the Mallard case. That's exactly the point on the Mallard case. And what the court said, well, it's their standard of living to have two houses, but nothing in the record indicates that they ever bought a home for $1.4 million. The highest piece of property prior to the North Carolina property that they ever bought was a fractional share of $300,000. The wife conceded that all of the real estate investment assets that they have, except the beach house in North Carolina, were investment. What she's asking to do now is take all of that investment income and put it into a beach house and not have any of it included into her alimony for purposes of what her income is. And I would submit that that is absolutely against what the Mallard court case says. And the husband should not be required to pay additional alimony because the wife does not want to reinvest her investment interest. It's the Italiano case specifically said that a marital home should be considered for investment interest. We're not asking her to do that. She has a mortgage-free marital home. I see I only have a minute and a half left before my rebuttal time. I'd like to save that if it's okay. Thank you.
You may.
Please support. My name is Linda Bailey, and I represent Linda James in this case. I think that the most important thing that the court needs to acknowledge is the standard of review, and we need to acknowledge that the trial court is the one responsible for resolving disputes and evidence. Unlike the position of the former husband in this case, there was volumes and volumes of evidence in this case. This was a full-day trial that went to 8 p.m. about the standard of living of these parties. And the court did make very specific findings of fact in both the final judgment and in the order denying the motion for reconsideration. The important findings of fact for this appeal were the undisputed fact of the wife's income of $45.73 per month and the husband's income of $49,047 per month. And that did not even include the $18,000 per year voluntary contribution he was making to his 401k. The husband vehemently took the position in the trial court and also took the position in his brief that his income was $240,000 a month. In fact, for every year but 3 years since 1990, this man made easily $500,000 a year, up to $750,000 per year. It was not just in the last few years of this marriage. It was a consistent income producer, and the court found, in fact, that it was. The court also found in the final judgment that they had a very high standard of living and did not believe the husband when the husband said he spent $100 per month on clothing and he spent $1,000 for his entire trip hunting in Argentina and $1,000 for his entire trip salmon fishing in Canada. The court simply didn't believe him. The court also found that significantly that the marital properties that we're talking about were never income-producing properties. Never throughout the course of their marriage was the real estate that these parties envisioned selling income-producing. In fact, it was undisputed that it required $7,000 a month in outlay to maintain these properties, and the lion's share of that went to their $1 million North Carolina home, which the husband referred to on his own that was his summer home. And also went towards expenses towards their beach house, and I believe he testified in 1 year he had to have a $35,000 outlay for repairs on his beach house. The court further found that the interest income on the equalizing payment was in the total control of the husband. In fact, she had not yet started receiving those interest incomes because he had 6 months to begin to initially pay the equalizing payment, and then he had 180 months to pay at 6% if he failed to pay. But at any point, and in his testimony, he indicated he wanted to pay that quickly and did not want that to last the entire 180 months. And the court further found that $10,000 was an appropriate level of alimony for the wife. However, the court said that is 30% of the total available income, which is probably low. When the court issued its order denying the motion for reconsideration, the court made further findings of fact which are important. The court ordered that, or found that the monthly carrying cost, the $7,000 per month, was part of the lifestyle of this family. Their lifestyle was to have a second home, was to have actually a third home, that they had a primary residence worth $750,000. They had $1 million house in the mountains. They had a $2 to $3 million home on St. George Island, and they had a penthouse condominium, they had a golf condominium, they had other real estate that the court's aware of. And the court found that it was the lifestyle of this party to have not one, but 2 vacation homes, and that $7,000 per month was the lifestyle of the parties to maintain these homes. The court further found that the wife had a total need, consistent with her financial affidavit, of $16,927. But the court did, at that point, indicate a recognition that there was going to be a tax implication of that award of $3,644, which brings her need up to $20,571.
But how can you say that the judge abused his discretion by not including this 3640 when the case law says he must consider it? And obviously he did consider it and elected in the total scheme here not to give it to her.
Well, I believe what the case law provides, Your Honor, is that if he found her need to be $20,000 roughly per month, and that there's an ability to pay that need, then it's erroneous application of the law to not award her entire need. And that's my argument. So if there's competent substantial evidence, which I believe there is significant evidence to sustain her need at $20,000 per month, then it's the obligation of the court to grant that need up to the husband's ability to pay. And in this instance, the husband does have an ability to pay. And the court...
So you say as a matter of law, we have to reverse the trial judge on this point?
On this point, we do.
It's not discretion in this set of facts, it's de novo? Is that what you're saying?
I believe it is, Your Honor. I think that the abuse of discretion applies to the findings of fact. I believe there is no abuse of discretion in finding her need as she presented, considering the tax implications, but then the application of law would be to grant alimony as far up to that need as she could, provided there was an ability to pay, which I don't think there's any question there is an ability to pay. And the court further found also in the order that the wife's need was clearly beyond the gross income of $14,533, which was ordered by the court, which presents a net income of less than $10,000 per month. The court further stated, as you recognize, that there was no overstatements or unwarranted claims of expenditures in her financial affidavit, and the court did not find the husband credible when the court ordered or found that it was a myth to say that they lived on $240,000 per year. There was ample testimony, Your Honor, about their large homes, about their vacations on 3 continents, about him hunting on 3 continents, hiring private airplanes to fly them to remote rivers in Alaska to salmon fish, to stay at former royal palaces outside of London to go pheasant hunting in full olive drab, to rent villas in the Cotswolds, to rent villas in Tuscany, to stay in palaces in Spain, to take all kinds of family members and sisters and brothers and mothers on these vacations. They antique shopped on vacation. They antique shopped in the mountains. They went to auctions. They had his office, their homes, all of their homes filled with individual artwork, original artwork, oriental rugs. At one example was a $5,000 glass vase that they bought. They went to auctions and spent tens of thousands of dollars on a whim. And this is the lifestyle that they were used to. And these are all legitimate expenses. The court in Mallard contrasts the lifestyle in the Firestone case versus a lifestyle where mere mortgage payments and maintenance on a townhome may be appropriate. And so there is a range of lifestyles depending on the individual facts of every case. And this case may not be helicopters and routine use of private planes like there is in Firestone, but certainly there's ample evidence to show that they lived a very luxurious lifestyle. And they did that based upon almost 2 decades of significant earnings that would not have been possible had my client not stayed home, worked in the business, taken care of the children, taken care of all of the household responsibilities, left her job in the mid-1980s as a phlebotomist in order to help the husband in this business. And that has to be considered as well. There's no way that this man, the way he traveled and the way he worked, could have been that successful without her taking care of everything else. Because he was traveling, she's home, he would not have a family, he would not have children, he would not have had many of the nice things that he had his wife not been there allowing him to devote his attention to his employment and to his success.
Opposing counsel said this ought to be reversed and sit back for findings of fact on everything. What's your response to that?
The court made specific findings of fact. The court listened to a full day, and I think at some point got frustrated by the in-depthness of the testimony that was presented to the court. We went through bank records. We went through checking account statements. We showed where thousands of dollars were spent by the husband every month furnishing his North Carolina home, paying for quail hunting trips in Georgia, paying for trips to Argentina, paying for his annual fishing trip to Canada. We went through extreme and excruciating detail on the facts of their standard of living. And the court made very specific findings of fact about their maintenance and upkeep expenses on their vacation homes, about the fact that 2 vacation homes was their standard of living, about the fact that the numbers in the financial affidavit, he obviously had gone through them and found them not to be overstated but to be reasonable. So I think there are very specific findings of fact as required by the law. I agree it is required, and I think that the court satisfied that, and I think the evidence presented to the court more than satisfied that. And the cases that are referred to by the appellant have to do with cases where no evidence was presented to the court regarding findings of fact, and the court merely stated, I'm going to grant 30% or 50% of the total available income. And in several of those cases, that percentage would even go on into the future. So as incomes adjusted, alimony would adjust without any future showing of need, and that's not the case in this situation.
So what specific relief are you asking us for on your cross appeal?
What I'm asking for in the cross appeal is to order the judge to award alimony pursuant to and in the amount of the finding of fact he made, supported by competent and substantial evidence of her need. And we're asking that that award be, to be consistent with what I was asking at trial, $17,000 per month.
$17,000 a month?
Yes, sir.
And that figure would include your claim for taxation expenses on the alimony?
Yes, sir. I believe that results in about a net income to her of about $15,000 per month. At trial, I took the position not as an admission that this would be appropriate, but just as a trial tactic to appear to be overly reasonable, is I granted her the benefit of a $2,300 a month interest payment. The court stated that that interest payment is not predictable, it's not reliable, and in fact that's true, and we discussed that earlier. The husband could agree to pay that at any time, and she has other expenses and things, and so that money would be her money. It's not necessarily investment income, and it's not in her possession right now. And I think one of the reasons that their claim fails for adding interest income or passive income to this real estate is the fact that there is no cash. There is no cash. Right now we have significant parcels of real estate that are on the market, have had no offers. All they have ever been was an outlay of funds, not a source of funds. It's completely hypothetical as to when they might sell, at what amount they may sell for, and there's no cash. In every one of the cases cited by the appellant, the wife, in every situation I believe it was the wife, was awarded investment portfolios, rental income, cash. In this instance, what we did as attorneys is the husband's attorney and myself sat down and we worked out what we thought would be the fairest way for everybody to take the same hit on market conditions or whatever to come up with a very equal split in assets. And so we agreed for everything to be put on the market, everybody maintains it. When it sells, everybody gets the same amount. It's an equal way to do it. But what the court found was that there was a standard of living that allowed these parties to have 2 vacation homes. In this instance, the stated intent by my client was that she intended to take her real estate money and put it into real estate. And in fact, the marital settlement agreement contemplated in paragraph 1.8 that there would be a possible 1031 exchange because the home on St. George Island was held in an LLC, and there's specific language in the marital settlement agreement which said all parties in the LLC shall cooperate in any 1031 exchange intentions by either party. So that was something that was contemplated in the marital settlement agreement. It was something that my client had always contemplated and testified in court she had contemplated. So it's not applicable to this case to apply cases like Italiano because my client was not awarded an investment portfolio and was awarded 1/2 interest in real estate, which may at some time in the future sell, which she intends to convert to real estate consistent with her standard of living.
Are you really asking for $17,000 or $20,000 because of the tax consequence?
I believe I could rightfully ask for $20,000. I'm asking for $17,000.
Okay.
The position that the husband would like you to take, Your Honors, is that Dr. James walks away with $600,000 a year in income. Whatever his half of the assets may turn out to be, he can wrap them into however much real estate he wants to, and he goes along in life with absolutely no impact on his life. While my client lives in a 2,200 square foot home, which is the only thing she could afford during the course of this marriage, or during the course of this divorce, because she was not getting temporary alimony at any significant level, and that she's not allowed to spend any of her equitable distribution because she needs to leave it in a bank account in order to pay herself, despite the husband's huge ability to pay alimony. And in that event, he might as well have kept all of the assets because she can't spend any of it if she's going to lose her income. And that makes no sense whatsoever, and that's very inequitable given the length of this marriage, given the facts of her contributions to this marriage, to her contributions to the business, and given the facts that have been found by the court, which are supported by competent substantial evidence. Thank you.
Thank you. The Mallard Court found that the amount of money spent on comforts and joys does not include saving, investing, and asset accumulation. Any asset accumulation is taken into consideration by the asset distribution. I would submit to this court that the trial court made a significant reversible error as a matter of law by not including any of the investment income for alimony purposes. If the court did so, she's receiving $1.4 million, not including retirement accounts, which raises it up almost another $1 million, in asset distribution. That's $7,000 a month available passive asset interest to her. She's got $2,300 from the $500,000 that we know she's getting, and that is somewhat in her control. She's either going to get the 6% from the husband or she's going to get it from an asset. It doesn't matter which way it comes. And then she's got almost $4,600 of her own income. That's $14,000 a month of income that the wife has available to her. The court only didn't consider any of that. They didn't consider $9,000, and that's what I think is reversible error in this case.
Counselor, the court did say that the wife's needs, as established in this marriage, are clearly beyond her total monthly income of $14,533. Now, I know you're telling about all that she got, but she's entitled to that for equitable distribution, and that doesn't have anything to do with him being under an obligation to pay for the standard of living to which she became accustomed, does it?
That's true, Your Honor. However, the Rosencan versus Springer case, the Donoff case, the Elliott case, and the Mallard case all indicate that when a wife receives substantial assets which can provide income to her, that needs to be considered in passive income attributable to those assets. In the Donoff case, this was even a marital home. She makes a lot out of the fact that she's living in a 2,200 square foot marital home now. So is he. They're both living equally. And for her to have over $14,000 available to her as alimony and then another $10,000 for him, without the court really considering this, the court did not consider the investment income. It said it was neutral. There are 7 to 8 real estate properties. It wasn't just the beach house that was part of the real estate property. It was all a part of it. And that is what we're asking the court to consider as well. Thank you.
And your time is up.
Yes, thank you.
The court will be in recess for